This is William and Lonsdale, a podcast about the legal ecosystem and the fascinating people who make it tick. Today, your host Michael Green speaks with the Hon Anthony North KC. Tony has been involved in some of the largest cases in Australian history as both a barrister and a judge, including the pilots' strike in the late 1980s, the Patrick's waterfront dispute, the Tampa Affair and multiple native title cases. He is currently the chair of the Victorian Law Reform Commission, working on many fascinating projects, including the incredibly important work of improving the response of the justice system to sexual offences. Despite his impressive CV, like all of us, Tony has had his doubts throughout his career. But he always remembers some sage advice given the night before his first case as a silk, which helped him keep things in perspective.
The High Court welcomes new silks at the beginning of the first sitting, and there's a dinner the night before. And so I went up for the dinner, and as you say, I had the first case in the list in that sitting, my first case as a silk. And so that was a terrifying experience, and it was quite a difficult case, a case which even today is still a foundation case in discrimination law. But I remember wandering along the outside of the High Court to the dinner thinking, what am I going to do tomorrow morning? And up behind me comes Hartog Berkeley, a bit of a legend of the bar, and he says to me, "How are you going, Tony?" And I said, "Hartog, I am absolutely terrified. You know, tomorrow morning I face the seven, and this is my first case as a silk." And he said to me in his inimitable accent, which those at the bar will know, he had a sort of a lisp, he said, "Don't worry, Tony," he said, "they don't even listen to you anyway, they'll make up their own mind."
Our guest this morning in Lives in the Law is the Honourable Tony North KC. Tony, good morning.
Good morning.
Tony, let's go back. You've got a very interesting childhood in that your parents both came from pre-Second World War Germany. Can you give us a bit of background as how they got to Australia, where they came from in Germany, what the impetus was for them to come to Australia?
Sure. I chose them carefully, Michael. My father was born in Strasbourg in 1916, so it was German for a few years. And then, of course, after the First World War became French, and consequently his first experience of being a refugee was moving from Strasbourg into Germany. I think they went to Nuremberg and lived there. My mother, on the other hand, came from northern Germany, now Russia, a place called Königsberg. Prussia was a centre of strict sort of Victorian philosophy, and she was brought up in a family of very, if you like, conservative, in a conservative community. The Prussians had a certain reputation which contrasts, if you like, with the Bavarians where my father lived, and that difference in background, I think, is reflected in the team that they became as a married couple. So my father had the misfortune to turn around 16 at the time when the race laws were introduced into Germany, and he had intended to become a lawyer in Germany and went through, presumably, his schooling with that in mind, and hit a brick wall when it came to the moment when he would otherwise have gone to university. So he had to readjust and rethink. Hitler had come to power around that time, so he followed a sort of commercial apprenticeship in the next few years, but realised when it came to around 1937 that Germany was not a place to remain. And he migrated to Australia in 1937 with his sister and brother-in-law. My mother, on the other hand, left Germany to arrive in Australia on the day war was declared. So her family went through, in 1938, the horrors of Kristallnacht, the day on which Jewish families, homes and businesses were ransacked by the Nazis in a concentrated attempt to terrorise. And she told the story later in her life of being around a 13-year-old, of the Gestapo turning up at their flat and roughing them up. But in particular, she was standing there with a little doll, and she remembered to the day she died in her 80s, the Gestapo officer saying to her, "You will never have children." And you can imagine how that played out to her in later life. And so anyway, she arrived in Australia and went to school here at McRobertson Girls High. And then my parents married in 1946. In the meantime, after migrating, my father joined the Australian Army, thinking that Australia, having welcomed him here as a refuge from being ousted from Germany, that the least he could do would be to join the army. Having come from that background, the rules in Australia were that people like that were not sent overseas to fight. So he spent the war in Tokemwal transshipping goods from one gauge to another, with a whole lot of other European men, including the famous Danera boys.
Just for the younger generation, Tony, younger than you and I who don't know, but at that time, each Australian state had its own railway gauge.
Yes.
And you had to change trains or transship cargo, like your father did, at each state border.
Correct.
Yeah, and
Correct.
He spent the war doing that.
He did.
Your parents coming from, and your grandparents, I guess, coming from that terrible experience in pre-war Germany, did that inform your childhood? Were your parents, was that sort of a constant, not so much topic of conversation, but something that hovered in the background the whole time?
Well, Michael, that's, I guess, one of the most important questions in looking at my life thereafter, because my father was really my best friend, and we were very close. And yet, to my great frustration, he never talked about Germany, and I never asked. And it's only in later years that I've become interested, well after he died. And as I say, it's a real frustration because I don't know anything about, where he went to school. I now know because we've done some tracing about that, but I don't know how he felt about it. But I do know a sense of burning, unremitting fury and sense of injustice throughout the whole of his life coming from that experience. That was something that he didn't need to say. I don't know how it gets transmitted, but I certainly understood that there was a deep-seated, smouldering, unbelievable power of, fury against the injustice of the mere fact that he, as a Jewish person and one who wasn't a deeply practicing Jewish person, could be thrown out of his home country, his career disrupted, and of course his community murdered, including a distant relative of his, I think it was an aunt, who died in Theresienstadt. And he just, you could feel the inexplicable horror of his views. So that definitely came through, and I think informed a lot of my life's outlook. On the other hand, my mother, and I think they made a perfect team, she came, she was a very warm personality. She was much younger when she came out. She didn't have the same sort of memories. And so her sense of history was not as consuming. But my father was a deep-thinking man, a very sort of conscientious person. And I think it just was beyond his contemplation of fairness that this could happen.
He must have been successful, or your parents must have been successful from a business point of view, because I sent you to Scotch College, a private school with high fees, I guess, although maybe not as high as they are today. How was your experience at Scots College? You were a conscientious cadet?
No, I was a very unconscientious cadet. The story of the cadets at Scotch is, again, a really important thing to understand about my future trajectory, because I don't remember much about my schooling. I've got a bad memory about the past. I think I'm a future-focused person. But the thing about the cadets and Scotch was this, that I started Scotch in secondary school, so I was 13 or 14. And when I started, I was offered to go into the cadets or to go into Scouts. And I had this desire to wear a uniform, be like the blokes, carry a 303 on the number 69 tram. That was just my vision, a blue beret with a red pom-pom and a kilt and big boots and white spats. It was just such an alluring thing for a 13-year-old. And my parents, like very enlightened, they didn't say to me, you can't do it. They said, in effect, I don't think it'll suit you. We know you quite well, and I don't think you're going to like it. And then I said, but I want to do it. They said, well, think carefully, because we can't see this producing any good. Anyway, I did as 13, 14, 15-year-old boys do. I did, and I donned the kilt and the pom-pom hat and carried the 303. And that was a very, very, uplifting moment for me. And
Can I butt in, Tony? I'd like to say, for the younger generation, number one, a 303 is a rifle, and they were a big rifle. They weren't a small
very heavy
thing.
rifle.
And that tram running up and down Glenfrey Road was full of school kids carrying rifles on the days of cadets.
Absolutely.
It's amazing in today's world to think that, but it was.
Yeah, absolutely.
So, sorry, please go on.
So that was all fine until shortly after starting, we got down to the business of killing people. We enacted that on the school oval, where the cadets had erected posts with bags full of straw. We were asked to attach a bayonet, which is a long knife, to the end of our rifle, and on command, go and murder the bags. All of a sudden, I began to understand what my parents had been counselling me about. It was quite actually a traumatic experience. And I thought to myself, no, I'm not really suited to this. And so I went home, and this all took a little time to happen. Went home and said, well, I don't think I want to continue. And my dad said to me, well, we told you, you made your decision, so you best try and do what you must to get out of it. But I don't plan on helping you because you made the decision and you live with it. And so I made an appointment to see the headmaster of the school to ask to be relieved of this cadet service. And that was a pretty forbidding thing for a 14 or 15-year-old person. The school headmaster was a fellow called Colin Healy. He came from Britain. He was a small man, but a man focused very much on discipline. Do as I say, when I say it, and quickly, and don't ask any questions. That was the sort of mentality of a headmaster of Scotch in those days. So I go along and the door opens and there he sits behind a very large desk in a timber empanelled study and says, what are you here for? I said, well, Mr. Healy, I really can't continue in the Cadet Corps because I just can't do the exercises that involve, murdering straw bags. And he said, well, that's too bad because you're staying in. And it was about as quick as that. And this, bear in mind, as a 14-year-old, I was terrified. But at that moment, something rose in me to interrogate him about it, to ask. And I said to him, well, Mr. Healy, what do you expect then that I'm going to do? Because I'm not going to be doing that. And I saw him transformed in anger. And he just said to me, I've made my decision. That's what you will do. So I left there, but I felt this amazing empowerment because I saw him as a man possessed by anger, losing control. And that is an empowering experience. And that's something that I stored away for later recourse in my own career. I then went home and told my parents, and my dad, he was just such a considered and reasonable person. And he said to me, well, you've done your bit, that's fair enough. And I disagree with the headmaster, and I will tell him that, and we'll see what happens then. So he wrote, and of course the school then capitulated and I was out of the cadets. But it was a very important life lesson in all its respects about taking responsibility for your decisions, taking it as far as you can go, seeing the consequences of someone losing their temper and how it empowers others.
Late 60s, early 70s, you go to Melbourne University, you do law and arts. Anything particular about that time which stands out in your memory?
What stands out is the era and my interest in what was happening on the campus. I mean, law school I found congenial. I enjoyed the intellectual challenge. I had friends there and it was all very comfortable. But what was going on around us was firstly the anti-apartheid movement and the objections to the Vietnam War, because I was actually balloted into the conscription for the Vietnam War and was deferred because of my university studies and never had to serve because of that. But particularly the anti-apartheid movement really sort of galvanised me, and I followed it carefully. And I guess, you see the theme of my background at home and the persecution of black people in South Africa, they weave a fairly consistent web.
You do your articles, and I won't dwell on them. What I find very interesting is after your articles, you become an associate to Sir Ninian Stephen in the High Court of Australia. That's not a common thing for people to be associates to a High Court judge. How did it come about? What was it like working at the highest level of the law in Australia? What does an associate do apart from sit in front of the judge in the court and look out at the practitioners and the parties?
How it came about, Michael, was that a good friend of mine whom I'd met at uni and who lived nearby, David Habsburger, who became a judge of the Supreme Court, he was the associate to Sir Garfield Barwick, the Chief Justice at the time. And he rang and said, look, I know that there's a position available with Sir Ninian, who was, I think, then the most junior judge on the High Court. Why don't you go and apply?
And you'd had no thoughts of you'd like to be an associate, maybe it's a stepping stone to becoming a barrister?
Look, I don't remember, but I'm sure that I certainly had in mind going to the bar at that stage. And yes, it was a fairly traditional course. If you're able to land an associateship, it was a very good way of getting into knowing about the bar. And so what did I do? Well, mainly interacting with the judge, that is, going into court, listening to the cases, coming back out, talking with him about what had happened in the courtroom, which meant talking about the law, talking about advocacy, and then possibly being given some research to do on a particular point. But, oh man, was I naive. I mean, I can't believe now, looking back, how little the law school equipped us for the practical world. Quite different now. Now judges and retired judges go up to the law schools and talk to and mentor law students, and there are clinics where law students actually conduct cases under supervision. This is all totally new from the era when I did it. And I came out really, how little I knew is quite sort of farcical now. And Sir Ninian was very approachable. He was a lovely teacher. There was no restriction on the time that he spent with me. And I'm sure that the traffic went one way, not the other. I look back and I think, oh boy, what a liability I must have been. The notion of me actually writing part of a judgment, it just brings hilarity to my mind. There's one experience of the High Court that I think again marks my later career, And that was my very first day. It was actually right in the middle of my honeymoon. So I came from Wilson's Promontory, where we were honeymooning, to Canberra for the opening of Parliament, where all the High Court judges attended. First day, hadn't met the other judges, go into the Senate committee room on the front of the old Parliament House. And there were the 7 High Court judges pulling on silk stockings, silver-buckled shoes, and their Windsor jackets, including the very aged Sir Edward McTiernan, who was sort of shaking in doing this. And all of a sudden, the vision of the pomp and majesty of the judiciary was put into its proper perspective. And that vision has never been lost on me thereafter.
There's a phrase, something to the effect that no man is a king or something like that to his butler.
Yes, exactly. Exactly right.
Having seen the person in that state, they're a fellow human being.
That's right.
They're not gods.
That's right.
You do an interesting thing, and an atypical thing for this time, which is the mid-70s. When you finish your period as an associate with St Ninian, you go to London and do a master's.
Yeah.
It's typical today. Lots of law students or law graduates go and do postgraduate degrees overseas. But in those days, and you and I are contemporaries, that wasn't typical.
No, but it was also not uncommon. In London at the time I did it, there would have been 4 or 5 others who later went to the bar. It was assisted enormously by the fact that I think there were no fees or very small fees to do a master's. Now, that changed very soon after, and it became very expensive. So, the financial side was not an issue. And as far as I was concerned, I had finished with the High Court and earned quite well for those times. And I'd just been married, so we had this idea of, doing our overseas travel. My wife worked at Australia House and supported us. Yeah, and also I had in mind at that time a career in international law. And of course, the London School of Economics was a centre of learning for international law, and I did a couple of international law subjects in my master's.
Tony, you come back from doing your master's in London and join the bar. For the first 10 to 12 years, you have a typical junior barrister's practice, general work, learning your craft across crime and civil stuff and crash and bash and whatever else comes across your table.
Yeah.
Then industrial law starts to become prominent in your practice until a stage, I guess, where it dominates your practice. How did that come about?
Well, that's an interesting story, Michael, because when I first came to the bar, I was in equity chambers, and there was a group of us, indeed a group that's still together today for Friday lunching, but it included my very good friend Peter Gray. And Peter was the leader of the bar in Victoria in employment and industrial law in those days. And he was appointed to the Federal Court at a very young age and all of a sudden was gone, and there was a gap in this area of law in Victoria. And the solicitors that briefed him, principally John Ryan and Orm Thomas in the firm of Ryan Carlisle Needham Thomas, gave me a tryout, and we got on extremely well, and I really loved that area of the law. I might say an area of the law that I hadn't done at university and hadn't practiced in until then. And one thing led to another. They were obviously happy with my work. I was happy with doing the work, which was acting in industrial cases on the side of the unions in an area of intense industrial action in the 80s. There was a lot of industrial action surrounding Section 45D of the Trade Practices Act, the secondary boycott provision which prohibited acting against one person in order to influence a third person. So my practice developed quite fortuitously in a different direction altogether than where I'd been going. I really had no plan. no strategy, and fate just took me by the scruff of the neck and directed me into an area which really suited my personality and interests, I think.
And just to clarify, it's an area of law which then, and even now I think, is completely divided. You're either on one side or the other. A firm like Ryan, Carlisle, Needham, Thomas only acted on behalf of unions or workers, and barristers likewise only acted on behalf of unions or workers or on behalf of employers. Rarely did people cross the line.
Rarely, but there were some instances. I remember Don Ryan, I think, acted on both sides, but
a fellow federal court judge with you.
Yes, but yes, this wasn't really because of any sort of sinister political allegiance. It really was because you, like with any client, be it a bank or an insurance company, if you act for them regularly, you get to know their strategies and secrets and confidences, and you build up a rapport. And I think that is a fairer way of looking at it, because I hope that I never appeared, because I in fact am not, ideological, and most of the barristers practicing in that area, even though it was a very highly politicised environment in those days, but the bar took seriously its independent role and didn't carry the sort of political slogans that their clients did. But on the other hand, there was an allegiance to particular clients and also perhaps to the fights that they were having at the time.
And one of those fights, which became a major fight in Australia in the 80s and a major, a milestone really in the industrial law in Australia, was the pilot strike in 1988, which you became involved in. Maybe give us a bit of a history lesson here, a brief one. What was the pilot strike and how did it develop, and then how did it become finalised?
At that time, the industrial framework did not allow bargaining between individual groups of employees and their employer. So that form of bargaining was on the horizon, but it was a new thing. Previously, the industrial structure provided that employees were paid in accordance with awards which covered everybody and were fixed centrally. And all of a sudden there became a new approach to wage fixing, and that was you could bargain, firstly collectively, and then this was a moment where the pilots said, well, we actually just want to talk directly to Ansett, our employer. Now, that was resisted by government and by the union movement too at that time, interestingly enough. But the pilots, they thought they had a lot of industrial might and muscle because, of course, they thought they were the only workforce available, and they were relying on that in their attempt to negotiate directly with their employer.
That they were irreplaceable.
Correct, yeah. Correct. So they came, I was briefed on behalf of the AFAP, the Federation of Airline Pilots, initially I think on my own, to advise on their strategy, their industrial strategy. And they were very gung-ho. They were convinced that they had their employer over the gun. And so they determined that they would take industrial action and withdraw their labour, and they did that. I think it was about that time when the pilots brought in a leader for me, because the issue arose that the employers were contemplating suing the pilots for damages. Individually, for failing to fly and disrupting. I mean, Australia stopped. There were no domestic flights at this time. So the pilots were very concerned about being sued. And they said to us, well, we're irreplaceable. We're not threatened by these suits because the employers are going to have to take us back. And so we're asked to advise whether what should they do in the face of the threat of action. we said, well, there is a danger about being sued. And they said, oh, well, what about if we all resign? They can't sue us if we're not employees anymore. Having, by that time, practiced in industrial law for some years, I was very, very uncomfortable with the idea of the pilots resigning en masse to avoid common law actions. But they were resolute in their view that there was no alternative workforce. And so me and Neil McPhee were bound to say, well, if you reckon you can't be replaced, then you will ultimately have to win against the employers. So we saw this amazing thing happen before our eyes where all the pilots in Australia flying domestically resigned. And as I said, there was no plane flying. Well, the government reacted by two steps which had not been anticipated by the pilots. The first was to allow foreign pilots to come in and fly planes, and the second was to use the military to fly people around Australia. And that was the beginning of the end of the dispute, because all of a sudden the pilots' confidence in being able to cow their employer sort of dissipated. But they were a very, very resolute mob and a very collegiate mob, so they stayed together for a good few months. But the employers devised strategies to win some back. They put deadlines on a return to work and said, well, if you return to work within X period, we'll take you back, but not after that. And they stuck to that. And a lot of pilots were spooked, and first it was a dribble and then it was a flow. And by, I think, towards the end of that year, that there was enough pilots back together with the Americans that the planes started flying again. And but I mean, in that period of 9 months, there was hardly a week that went by where I wasn't arguing before the industrial tribunal at that time about one application or another, at the very end urging them to mediate, urging the commission to mediate, urging indeed the president of the commission to mediate. But the world was a Guinness because somehow or other those in power, and Bob Hawke in particular, were not prepared to let the pilots fracture what they thought was this system. What was curious was that I think it was within about a year afterwards the law was actually changed so as to allow direct negotiations between employer and employee at a workplace, a system which applies to this day. So the pilots were just a little bit too early, and it wrecked a lot of lives, a lot of pilots and who had spent years and money to get to flying and had a passion for it, and they ended up having to leave that occupation. And this all became very clear in a proceeding which lasted for about another year, in which I was briefed to try and uphold the right of the Federation to continue to represent the industrial interests of pilots. And the way we ran that case was to call one pilot after another to say, we want the Federation in there. This is how the dispute affected our lives, and we need the protection of a body with this sort of industrial clout.
But from the pilot's point of view, ultimately it was an unsuccessful action because of their misjudgment that they were irreplaceable.
Quite.
Tony, you're appointed to the Federal Court in 1995, after you've been a barrister, I guess, for about 20-odd years. Was being a judge something you'd aspired to? Something you'd always had half an eye on, thinking, at some stage I'd like to be a judge? In those days it wasn't uncommon for senior barristers, that was almost their superannuation, was to become a judge and get the judge's pension. So were you aware of it, or did it come out of the blue for you?
I wouldn't say it came out of the blue, but I certainly didn't aspire to it in the sense of sort of creating circumstances where I would be asked. I remember very well my last conversation with my dad before he died, and he said to me, This was a couple of years before I was appointed. And he said, would you like to be a judge? I was quite impatient, I remember, with him saying, well, I've got no control over it. It's just, I'm working away. I'm very busy as a silk and I'm enjoying that. So, nothing to talk about really. And that was my attitude. And indeed, it's a theme that needs to be seen throughout my entire career, that I didn't actually strategise. I didn't actually decide to go into industrial law. It dropped into my lap. And similarly with becoming a judge, I was working away and I thought, well, maybe that one day it'll happen. I didn't seek it. I didn't do things in order to get there. I just worked away as a silk and had a really enjoyable, even if overly busy life.
That being the case, and busy silks, it's pretty well a 24/7 occupation, being a busy silk. Were you pleased to be appointed a judge to give yourself a bit of time to draw breath and get off the treadmill?
Yes, I was. And I vowed when I was appointed not to forget the pressures of being a silk. Because, some people had said, this and that disadvantage about taking the appointment, but I was very happy to accept it. And as I said, I made a promise to myself to remember in hard times on the court that life as a silk was not always the best way of living.
Can we move on to native title? Because you did a lot of native title cases, and it's a phrase which we all know, and we know about Mabo, but really the detail of it, what native title actually means, I suspect most of us, including myself, don't really know what it means. We understand title to a house or ownership of something, but it's not ownership of something, is it, native title?
Maybe I should start by saying that native title and what I did, and as you say, I did a lot of it, again was one of those fortuitous things that dropped into my lap as a matter of great luck. Mabo was decided, I think, in 1992, and Mabo set up the proposition that Aboriginal people had a title to their land. They had rights like, as you say, title to your house. The government had to quickly scramble to ensure that pastoralists mainly, who had occupied sort of large proportion of the landmass of Australia, were protected. This is a very difficult social issue to grapple with. And there was a lot of political overlay, but as a basic policy issue, it is a very difficult issue to reconcile those two interests. Again, as a pattern in my career, I was lucky that we had Chief Justice Michael Black, who saw that this is an area that I might be, useful in, and put me into the early native title cases. And the very first case in native title that was conducted was in Western Australia by Justice Lee, who spent, I think, more than a year hearing and then determining the case of the Mirrawong-Gadgerong people. Later became known as the Ben Ward case. And that raised the very question you've asked about, Michael, what is native title? And what he came up with was a formulation which said that native title, under the Native Title Act, which tried to reconcile pastoralists and Aboriginal land rights, was a title to land, an underlying title to land. That case went on appeal. You remember? It's the first case ever. Michael Black put me on the appeal bench. I was on the appeal bench with John Von Duser, very senior judge, and Brian Beaumont. And I was a very junior judge. And the argument was, well, what is native title? And it was played out against the concept of extinguishment. Did the rights of the settlers to pastoral leases and to Crown grants, did they extinguish native title? Did they forever put an end to it? Malcolm Lee said, no. Once the Aboriginal people get title, they have an underlying title to the land. On appeal, the majority said, no, that's wrong. The Aboriginal people don't get a title. They get a bundle of rights. And you've got to look at each of the rights in the bundle, a right to burn, a right to live on, a right to hunt. And if there's not a continuity from the date of white settlement to now in relation to those activities, then the right goes.
Even if the continuity is broken by the white settlers.
Absolutely, and that is the fundamental weirdness of native title, that the people who are most affected by being stolen, having their culture removed, are the ones who are least likely to establish native title. Now, the thing is, in terms of my own career, I dissented in Murruwong-Gadgerong. I agreed with Malcolm Lee, and the case ultimately went to the High Court, and the majority was upheld, and the view of Malcolm Lee and myself was rejected. And that was the earliest stage in the appeal processes in native title, and I was there at the time. And I remained there in that jurisdiction right until the day that I retired. And that was an amazing privilege, both as a lawyer in seeing and being part of the development of the jurisprudence, and as a human being in conducting trials where I sat down many times with Aboriginal people, principally in Western Australia and Victoria, and heard their stories about their culture and their law and how it had been interacted by white settlement, and hearing their family stories and being moved beyond words time and time again, and being taken into their confidence by, for instance, being taken out to a corroboree in Western Australia in the dark of night and being shown the living culture of those people for them to establish this continuity which they had to do to establish native title.
About native title, you have said, or words to the effect of, native title as a legal outcome is pathetic. Native title as a practical outcome is transformative. Can you expand on that for me? What are you trying to tell us?
Well, what I'm seeking to say is that a determination of native title which sets out the individual rights in this bundle don't in practical terms mean, in many cases, very much, because the grants by government which are inconsistent with those rights override them. However, in two respects, and they're interlinked, native title is transformative in this way. The determination recognises, so it's a recognition of the existence of Aboriginal people in the area and that they had rights. But more important, in the practical world, the determination means that local authorities, state governments, Commonwealth government that want to act in relation to the land have to consult. I mean, it's funny, we're in the middle of talking about the voice. Well, native title in localities where it applies gives that voice. And I've seen how important it is, because if you sit down with Aboriginal people, and if you have to as a state government or a local government, and you hear why they are saying you can't build a quarry there or you can't build a road there, and you see their personal histories, all of a sudden there is a transformation. There is an understanding.
How did you conduct the cases, Tony? Wigs and gowns and buildings in the middle of the CBD of the various Australian capital cities, or did you go on country? Or both?
This was yes, both. But this was the genius of the federal court in, the early 2000s, when it picked up this jurisdiction and decided that the court would go to the people. It was not uncontentious at the time. There were some judges who said, there's no need to go out there. You take a helicopter, fly over it, and you'll know what the land's like. But no, what we found, the more enlightened ones, starting with Malcolm Lee, who did the first trial, and who set up the whole logistical arrangements. The court bought four-wheel drives. It employed people that could run outback expeditions, if you like. So we went out now, and now it's routine to go out to remote places sit down on the ground or wherever, often in the middle of an Aboriginal community, conduct the case with all sorts of different approaches. For instance, Aboriginal people often want to give evidence in a communal way, not just one witness, but mum with daughter and granddaughter.
And can I say, if mum and daughter and granddaughter are giving evidence, are father, son and grandson, are they able to be present hearing that evidence given? Or are there rules or laws, First Nation laws in the various groups, to say, well, men and women can't mix, they've got to be separate?
Yeah, well, good point. It's not so much that men and women can't mix, but there are certain areas that are secret to men and other areas secret to women. And evidence, for instance, of secret women's business can't be given to a man judge and vice versa, and or can't be given in the presence of male solicitors. So we had to work out how that is to be done. And there was a moment in my education in native title cases very early on in the first case I did, which is an example. So we were at Bidjadanga hearing the Karajari case in the Kimberley. First Kimberley case, the community of elders in that area were very concerned about this white fella court coming in and hearing all sorts of things about law and culture, because they had to establish the continuity of law and culture over the period since white settlement. So very apprehensive. And there was some secret men's business that was going to be the subject of evidence, and the parties had got together and they'd worked out how that was to be done. The last minute, one of the male lawyers who was to be there to listen to the evidence couldn't be there. So the solicitor for that side said, can we have the transcript? Ross Howie, who was acting for the applicants, said, no, you can't get the transcript. This evidence has to be given face-to-face. They couldn't resolve that issue, so on the day of the hearing, they brought the matter before me. And green as I was, I said to Ross Howie, well, that doesn't seem very... I don't know why you're resisting. I mean, you've agreed that the lawyer could hear the evidence, so why can't he read it? And he said, Your Honour, it doesn't work that way. Aboriginal law doesn't allow that to happen. The people giving the evidence have to see to whom the evidence is being given. And I said, oh, well, okay, I'll need to hear evidence about that in accordance with the authorities, so let's adjourn and come back after morning tea and you can tell me if you're going to proceed, thinking, of course, that he'd drop away. Came back after the break and Ross Howie in a bold voice said, call Pat Dodson.
Can I just clarify, are you in a courthouse now or are you outside on country somewhere?
We're sitting out in the middle of the settlement at Bidjadanga. So this is where we're under the trees and this is all being broadcast on a local radio network to the whole of the Kimberley because people are concerned. Pat Dodson goes into the witness box and he says, in effect, hey, listen, I've got to teach you something. He doesn't say it in those words, but he said, look, you're in my country. Our rules apply here. And you can't just come in and run roughshod over them. Now, in this situation, we are not prepared to give evidence unless the person is there because that's how we work. We will give such evidence as we think appropriate by seeing the recipients. And it was very much, you simply have to listen to me about what our law is in this situation. And I did, and did an extempore judgment immediately saying the transcript would not be available. The particular solicitor was stupid enough to then say to me, as we were walking to hear the evidence, well, Your Honour, can I take written notes of what's said? And I said, I don't think so. But it was an absolutely fundamental, foundational education for me, done in this authoritative way, which forever heralded the need to listen to this other culture when you're determining the case. And I carried that lesson with me until the last day of native title that I did.
William and Lonsdale is brought to you by Green's List, one of the leading multidisciplinary barristers lists in Australia. Green's List believe in promoting conversation around the ideas and issues that shape not only our legal system, but our wider community.
Tony, as counsel, you were involved in a case which crippled Australia, being the airline pilot strike, and as a judge on the federal court, you were involved in a case which I can't remember whether it crippled Australia, but it had the potential to do so, being the Patrick Corporation waterfront dispute. It was a fight with the unions, I seem to remember that, but I can't remember much more about it. Can you tell us about that dispute and how it was resolved, or did it get to a resolution?
What happened, Michael, was that the Patricks, they had an operation on the waterfront, loading and unloading ships. They had an industrial strategy which was aimed to make that operation more cost effective. And how they executed that was that in the dark of night, they locked the gates. They had dogs and balaclava-clad security people to lock out their, I think, around 1,200 workers. And this was aimed, I think, to put pressure on the MUA, Maritime Union, to concede on particular wage demands. And this was a new style of industrial tactic, if you like, a lockout dramatically performed. And the unions argued that that tactic was unlawful, that it was contrary to the industrial laws to lock out your workers in that situation. And they, on the day after, the morning after the lockout, they brought an application in the federal court to reinstate the workers pending further court proceedings. And I got this case as an urgent duty case. The duty roster for urgent cases was set well in advance. I mean, many weeks before the occasion. It just happened to be me. It was there was no selection involved. It came before me on an application for an urgent injunction to reinstate pending the court hearing. And that's a very traditional role of the court. This is not hearing the case to finality. It's just hold everything. This is unlawful on the face of it, and it's more convenient on balance to put the men back than it is to keep them out. And I found that completely compelling in using the well-worn test for what we call interlocutory injunctions. And so that's the order that I made. It then went on appeal virtually immediately, as I remember it, because the stakes were high, and I was upheld. And then very unusually for an interlocutory application, because these are sort of urgent, quick, you don't hear the whole case, you don't form a final view. So very rarely does the High Court take a case like that, because they say, well, wait and see what the final result is. But given the circumstances and the highly dramatic sort of factual situation, the High Court did take the case and also made orders that the workers be taken back until the case was heard.
Being the duty judge, or the judge next in line to take a matter, in 2001, brought before you the Tampa case, the case of refugees on a ship named the Tampa in the Indian Ocean and them being turned away from Australia, if I remember correctly. Can you give us a history lesson and give us what was the Tampa dispute about, and then how did that resolve itself or not resolve itself?
In doing that, Michael, can I just flag, similarly as with the Patrick's case that we've just been talking about, this case came to me as a duty judge. Now, Patrick's and Tampa, as well as native title, these were all enormous good fortune for me. And, it made a judicial career which was quite special, really. But I want to emphasise the fact that it was all luck, right time, right place. And that's why I feel such an incredibly fortunate person, that I got these amazing challenges that just happened because I was there at the time. And, it shaped a career on the bench. It had massive impacts on, my life as a judge, but it was all unplanned. It was all just darn good luck. So Tampa, again, sitting there, I remember we were in a judges' meeting and there was a bit of scurrying around. I was due to come on duty at, I think, 5 o'clock, and at 4:30 there was rustling and the registrars were running around. 5 o'clock, because I had just come on duty, they said, there's an urgent matter like now. There's a boat in the ocean with 430-something rescuees, we call them, who are on their way to Australia on the Tampa, which was a container ship. They'd been rescued at sea by the Tampa by a Danish captain or Norwegian captain. Their boat was sinking and the captain wanted permission to land in Australia. It was just before the election, and John Howard said that they were not going to land in Australia. That was a government policy position. I heard the case as a matter of extreme urgency, and again was one of those cases where all the eyes in Australia were on the federal court. So as duty judge, I then heard as a matter of urgency an application brought by pro bono lawyers on behalf of the people on the Tampa, and the issue, as it was presented at that time, was whether the ship should be allowed to land in Australia, and if, as the government was saying that it shouldn't, whether that was unlawful in that the people on the Tampa were being unlawfully detained. So after having heard argument over the weekend, in a very tight time frame, I ordered that the rescuees be brought to Australia and landed on our shore on the basis that they had been unlawfully detained by government. That judgment was delivered on the morning of 9/11. In the afternoon Australian time, the Twin Towers were bombed, and the next morning ministers of the government made the outrageous comments that it was people like those on the Tampa that were responsible for that type of terror activity, and that's why the judgment of the court was so untenable. Anyway, there was an appeal, I think, on the next day, where the Chief Justice, Michael Black, agreed in the outcome with my reasoning, but Justice French, who later was to become the Chief Justice of the High Court of Australia, disagreed, and he carried with him, as I recall it, Justice Beaumont, and my judgment was overturned, and John Howard surfed in to win the election, and unkind friends of mine then congratulated me for being in part responsible for his election.
Tony, this case of the Patrick Corporation waterfront dispute with the unions was 1998, so what are we, 25 years ago. You did something unusual at the time and you allowed cameras into court. Why did you do that?
I had, right from the beginning of my appointment, been concerned to show the public what happens in a courtroom, to dispel some of the misunderstandings about the drama of court cases, to show that the courtroom was a place that was rational and calm and was concerned with arguments backwards and forwards and hearing all sides of an issue. And so with the great help of Bruce Phillips, who was in charge of communications in the court and who was very sympathetic with the idea, when Patrick's came along, it seemed to me a perfect opportunity to demonstrate that. But it was early days, and the only cameras that had been allowed in court by that time had been by Justice Teague in the Supreme Court, who allowed a sentencing appeal to be recorded and then played afterwards. So in Patrick's, what we did was, as a first step, we allowed vision of the case to be recorded, and then later on, when it came to Tampa, this was another opportunity. You know, a high-profile case which was of interest to large parts of Australia. I thought this is again a time to show, and particularly in the context of debate about refugees, to show how the court works, that it's a case that hears people, that is rational, that is not ideological. So in Tampa, we took the next step and actually allowed cameras to record part of the proceedings and then replay it afterwards, so not live. Then, on taking that cue, when it came to the appeal, heard a few days later, and given the public importance, Justice Wilcox allowed cameras in court to record live the judgment in the case.
In the Tampa appeal?
Yeah, in the Tampa appeal. And now, I mean, those were sort of still early days, but I thought it was a really important thing to sort of generate. And it's caught on now to the extent that judges in the federal court, and I think most courts in cases that are of interest, will allow filming of the proceedings. Now, there are obviously limitations on that. In criminal cases or in cases that involve very personal sort of stories. But in Tampa, it was a case of judicial review. It's legal argument. Basically, there were some witnesses, but it was important to show the community what was the Commonwealth saying? What were the refugee advocates saying? I thought it was a perfect opportunity to let the public into the courtroom, which, of course, they are entitled to do if they're walking along William Street. I again, like with native title, I regard it's very lucky to have been there at the beginning of that sort of process.
Lives in the Law is proudly sponsored by City Maps Illustrated. Their recent publication, The Melbourne Map, is a celebration of our wonderful city. This stunning, hand-drawn illustration, which took more than 3 years to create, is available as an art print, jigsaw puzzle and calendar. The perfect acquisition for your home, office or corporate gifting.
Tony, I've jokingly written out a question here about your retirement. Despite the fact you are in your mid-70s, you're not retired. You're no longer a federal court judge, but you chair the Victorian Law Reform Commission, which I understand is a full-time position. We know the commission exists, and I'd like you to explain to us where it fits into the legal system, and I'd also like you to explain or tell us what role it played in bringing about change in the very important area of sex offences.
Yes, Michael. Well, the Law Reform Commission was set up by statute as an independent body in 2000 by Rob Hulls, one of the interviewees on this podcast series. And its role is to undertake inquiries referred by the Attorney-General. And also there's a process of self-referral in smaller projects called community law reform projects. And as it happens, only yesterday, our latest community law reform project about blind and deaf people serving on juries was tabled in Parliament. So we depend on the Attorney-General and her agenda for reform for the basis of our work. When we get a reference, we assemble a team of researchers, really smart, young, mainly lawyers, who go out into the community and consult with the people concerned with that particular area. And then we write a report, we give it to government. Government, in the case of attorney references, is bound to table it in Parliament, so it becomes public. And in the case of the sex offences project. We were charged with undertaking that inquiry just as the Me Too movement was gathering steam. I think it was about the time when Harvey Weinstein was charged that we got that reference. And so you can imagine, again, how luck followed me in doing possibly the most important reference that the Commission has done right at the time of Grace Tame and Brittany Higgins and the discussion about sex offences. We produced a report of 600-odd pages which set out a roadmap, as described, I think, by the attorney when she tabled it, for reform, and immediately the government accepted the recommendations about changing the law to encompass affirmative consent, so requiring perpetrators of sex offences to establish that they took steps to confirm that usually women consented to the interaction.
And previously that was not the case. Previously there was some burden on the woman to establish.
Well, the whole point of this reform, I think, leave aside what the law said before and after, because I think there can be debate about that. But the point of the reform was to change the way trials were conducted so that the focus was, instead of being on women, to justify their actions. You know, why were you wearing a short skirt? Why were you being flirtatious? Why didn't you report quickly? The focus, and not that those questions are irrelevant necessarily. They might be relevant to some extent in some cases, but the focus should be on the perpetrator to establish, well, did you ask, is it okay? Pretty simple, really. It's simple but very difficult, and we examined what was necessary to change the experience of complainants in the justice system so that the reporting rate would go up. It's ridiculously low. The reporting of sex offences is less than 10%. 1 in 5 women over 15 are said to have, we heard, experienced sexual offending in their lifetime. There's a huge attrition rate when they get to the police. And then there's a higher acquittal rate in the courts than in other offences. Now, all those things can be changed by changing the culture in the courts, changing the culture of barristers, educating children, and we went through all this, as well as some much more detailed recommendations about how trials should work, what jury directions, how they could be improved, and things of that nature.
Massive work. I mean, that's trying to change a culture which has existed for beyond hundreds of years.
Yeah, and that's the thrill of this work, you know, to come from 23 years as a judge where you apply the law as it is, and at some junctures feeling that this law is unjust, to a job where you're looking at the law as it should be. You know, that has been a very liberating experience and one that I've enjoyed enormously.
Tony, it'd be an understatement to say you've had an extraordinary career. You say it's fortuitous that things like Tampa and the pilots dispute and the Me Too movement and all of these things intersecting with your career and your trajectory. I don't know whether it's good luck or good management, but it's been amazing. You look back, are there any learnings? One of the things I like about lives in the law, I think about young lawyers, I think about students who are studying law, and I think it might give those people an insight into what a career in the law is like, to hear people like yourself speak. Are there any learnings that you would pass on?
Yeah, well, Michael, I've listened to many of your podcasts, and I knew this question was going to come, but I don't have an answer, you know, because as you can see, that my career was not crafted by me. It fell into my lap. And I mean, I just feel enormously grateful that I just happened to have these amazing opportunities. So you can't construct that. You can't strategize it. No matter how, you know, much control you seek to exert over your career, you can't. And things come out of the woodwork. I didn't do industrial law at university. How was I to know that I'd end up that being a major stepping stone in my career. So I don't have the qualification in a way to answer that question. I guess except for, that old hoary exhortation to just be yourself and, be open to opportunities. I guess, and I was thinking, maybe the best answer I can give to you is, because of the influence they had on me, be careful to choose your parents carefully.
On that note, we'll close what has been a most interesting and enlightening episode of Lives in the Law with the Honourable Tony North KC.
Thanks, Michael.
Thank you, Tony.
Show notes from today's episode can be found at greenslist.com.au/podcast. There you'll find links to things we've talked about in this episode, a transcript of the show, and some wonderful photos of our guests. If you're enjoying Lives in the Law, please tell your networks, subscribe, rate and review the show. Your host is former lawyer and Greens List clerk Michael Green. Our show is produced and edited by me, Catherine Green, mixed and mastered by Windmill Audio, and recorded by Alex McFarlane, who also wrote and performed all the music for the series. We're coming to you from the iconic Owen Dixon Chambers on the corner of William and Lonsdale Streets in our beautiful city of Melbourne. We acknowledge the Wurundjeri people of the Kulin Nation as the traditional custodians of this land and pay our respect to their elders past and present. There is no doubt that conversations about justice have been taking place on this land for thousands of years, and we are privileged to continue that discussion here today.